Thank you all for coming today. My name is Charlie Smith. I'm the state's attorney here in Frederick County. To my left is Laura Wilt, chief of the juvenile division, as well as Rebecca Clinton, who is chief of our violent crime unit. Those are the prosecutors that are going to be handling the cases against both of these young men. So just a little bit of a recap for everyone. This was an offense that occurred on September 20th over at the Great Frederick Fair. A lot of people are calling it the Great Frederick Fair assault. Obviously, John Weed, who was a 59-year-old man, was assaulted, unfortunately succumbed to that assault later and died as a result of it. So that's the case that we'll be addressing today. There was a detention hearing on September 23rd. That's a hearing to determine whether the young men are to be held or not pending future hearings. Judge Solt did hold both men at that point in time pending future hearings. So as you well know, I'm required to let you know that both of these young men are innocent until proven guilty in a court of law. So I've also let everyone know that from the very beginning, we're just going to let the police, let the sheriff's office do their job. We're going to let them investigate this. We're not going to make any charging decisions. We're not going to make any future decisions regarding this case until that investigation was complete. We've met with the sheriff's detectives on multiple occasions, numerous occasions, and we have guided them in what we felt was relevant for our charging decision. So they have interviewed everyone. I want to make it abundantly clear. They've interviewed any witnesses associated with the victim, any witnesses associated with the young men who are charged, any witnesses who are just unrelated to either. So it's been a very thorough, a very complete investigation, whether the leads came in through social media, whether the leads came from people who were directly there. They have interviewed these people, and we have obtained that information. So the investigation is substantially complete at this time, and we feel that we are at a place that we were able to make some future decisions or some decisions regarding this case. So because it is complete, we have decided at this point in time to file additional charges. We believe that based upon that investigation, additional charges are warranted against both young men, and therefore we have filed new charging documents in this matter with regard to both. With regard to the 15-year-old, that young man now stands charged with manslaughter, first-degree assault, and 2 counts of second-degree assault. Again, that was not what was charged originally. Initially, we did not know that the victim was going to pass away, and therefore the charges placed by the sheriff's detectives did not include manslaughter. They do now. With regard to the 16-year-old, the new charging documents now allege 2 counts of second-degree assault. One is for punching the victim prior to the deadly blow. The other one is for spitting on the victim when the victim was laying on the ground. So they're the two assault charges pending against the 16-year-old. Again, I want to reiterate that none of these charges give the courts exclusive original adult jurisdiction. We've gone over that in detail. They are not charges that enable a prosecutor to charge originally in the adult system. That's why they are not charged as adults at this point in time. However, there is a process that allows a prosecutor to file a petition to waive a juvenile charged as a juvenile into the adult system. And it's called just that, a petition for waiver. Based upon the investigation of the police, we feel that both of these young men should be charged as adults. Therefore, we have filed a petition for waiver of jurisdiction to the adult system on both the 15-year-old and the 16-year-old. Again, we can't charge them initially as adults. However, we can ask the judge, ask the court system to say, look at some criteria, look at the factors, look at the offense. We want them tried as an adult. So that's what will take place. That hearing will be had. So what happened today? The court heard argument about whether these young men should be detained. That was argument that was put on by both parties. The judge did agree to continue detention of both of the youth. Now, because we filed a petition for waiver into the adult system, that canceled the trial date. There will not be a hearing tomorrow. The trial date is canceled. That's taken off the docket. It will not be heard. Once again, when we file this petition for waiver, it eliminates the necessity for a trial date, and then we launch into a different stage of the proceedings with regard to whether or not they should be tried as an adult, not whether or not they can be charged as an adult, whether or not they should be tried as an adult. And so we have filed that petition to waive the accused to the adult system. Right now, they're both being housed separately. The exact facility location is not publicly announced by Department of Juvenile Services, and that's not relevant to us. The defense counsel argued that both should go home pending these future proceedings, again, or that they should reside with relatives out of town. That was denied by Judge Solt. At this point in time, we do have a status hearing on the waiver petition set for November 19th to make sure that Department of Juvenile Services background investigation is done. So what happens when we file that is that a background investigation is done by the Department of Juvenile Services. Both waiver hearings are now set for December 18th of this year. Both juveniles, again, are detained pending that hearing, and the judge did also announce the cases are going to be heard by two different judges. They didn't say who. We don't know who is assigned to the cases, but they will be two separate waiver hearings, two separate judges. Obviously, we have two separate accused. So what's a waiver hearing? There's a lot of discussion about what is a waiver hearing or what a judge decides in terms of a waiver hearing. So first of all, the victim and the victim's family are able to submit a victim impact statement, and that is to be considered by a judge during a waiver hearing. So we're going to consult with the family, which we've been doing throughout every stage of this process, include them in the process. They are part of the waiver hearing. They get to submit an impact statement. The court can waive this exclusive original jurisdiction if they determine that it is warranted by a preponderance of the evidence. It's not beyond a reasonable doubt like a trial would be. If they believe that by preponderance of the evidence that the juveniles should be tried as adults, then the judge will move that to the adult system. They look at the age of the child. They look at the mental and physical condition of a child. They look, most importantly, at whether they're amenable to treatment in the juvenile system. And then finally, they look at the nature of the offense. Obviously, it's a very horrible offense. And they look at the public safety as a whole. So they're the five factors that a judge will weigh. They'll hear from the defense. They'll hear from the prosecutors about each of those, public safety, about the nature of the offense, about the amenability to treatment, and that judge will make a decision about whether each of the young men will be tried as an adult. So that's where we stand today. So I'll entertain limited questions. I want you to know that I have to balance two different things here, okay? I have an obligation to let the public know about what the proceedings are, what charges are filed, what's next, but I have an obligation to the defendants, to the petitioner, to the respondents, to ensure that they have a fair trial and that there's not undue pretrial publicity. So again, I'll answer what I can, but I can't get into specifics with regard to the case because I have that obligation to those who are charged to give them a fair trial. Yes, sir.
Can you shed any light on the criteria that you are considering in asking the judge to try these two teenagers as adults?
Again, we can tell you that we're going to be arguing public safety. We're going to be arguing amenability to treatment or the lack of amenability to treatment. Based upon our investigation, I can't go into detail about the two young men. And obviously, the nature of the offense are going to be the three factors that we argue most heavily.
As it relates to public safety, in court today, the defense attorneys for the two teens argued that they don't have criminal past.
Right.
So can you elaborate a little bit more on why you made the decision to try to petition for these young boys to be tried as adults?
I really can't give specifics. I can tell you that we've looked at that factor and we have based what we know about them into our decision to file a petition for waiver. I can't really go beyond that.
And Mr. Smith, can you
Yes, sir.
shed more light on, some of us have seen the cell phone video or whatever, the
Sure.
chats, of what you believe happened there leading up to was it more than just saying, hey, can I have a buck, no get lost? I mean, what happened that led to the...
Obviously, I can't make comment unless it's on public record, and what Laura Welch has stated on the record previously and is public knowledge is that this was over the young men asking for money, asking for $1 from the victim, and that's what started the incident. So I really can't give any further detail about the sheriff's investigation, but I can tell you that that's how the two parties came in contact with each other.
Saying that Mr. Weed said something back besides no?
I can't comment on that. I'm prohibited by my ethics law statutes to make any comment about the facts unless they were put on the public record. Yes.
Well, I was just going to ask something very similar to what you were asking. On our social media platforms, it was said that the victim used the N-word, and that's why the punch was thrown. Is that in public record? Was that ever found out from the two boys? Did they ever say anything about that?
You know, I can't make comment on that. That's something that the sheriff's office would have to respond to. Once again, because none of that was put on the record, I can't make comment. I can tell you it was a very complete investigation. We did, as I previously stated, ask them to take a look into whether a hate crime was an appropriate charge in this particular case. It's not been charged. So, I mean, you can put one and one together, but again, I can't make comment on the facts of their investigation.
Can you
So
talk
is it
about the,
I was going to say, does a hate crime go both ways? Like what was said and what was physically done? Or are you just talking about the physical attack as allegedly, possibly being a hate crime?
Again, the physical attack, there's a separate charge for hate crime in Maryland, and I told you that if someone assaults someone based upon their race, ethnicity, religion, gender, that you can charge that offense. That was something that, because there was some intrigue about, we asked the sheriff's office to investigate. I can't tell you what the facts of that investigation revealed. I can only tell you that a hate crime is not charged. And our charges are based strictly upon what the sheriff's investigation reveals. So we don't tell them what to investigate or not. We just take a look, make sure it's complete and thorough. We guide them in that investigation to some degree, but that's an independent investigation that we look at based upon the facts revealed in that investigation. We as prosecutors make a decision to charge. A hate crime was not charged, and that's all I can say.
For
Going
the
back to
hearing on November 19th, can we see a decision there, or is it later when just decide whether to waive them in the adult system?
That's really based upon the Department of Juvenile Services. We request an investigation. They do a very complete investigation with regard to each of these criteria. They'll take a look at any history they have, family history, any history of involvement with the courts, school history. They will render an independent investigation, and we'll take a look at that. So will the judge, so will the defense. We'll argue off of that. So when that'll be completed, well, we're hoping it'll be completed by that date, but I can tell you that it's not uncommon for the investigation to not be complete by that first date that's set.
can you talk a little bit more about just how significant these charges are for these young teens? I mean, what does it carry in terms of years in prison?
I can tell you that the manslaughter count is a 10-year maximum. But I've really, again, I can't elaborate on what it means to them or what it means to us. We take a look at the investigation. We charge, we take a look at the facts. We take a look at the law. We make our decision, and that's what we did here.
Mr. Smith, is the 16-year-old not charged more seriously because his punch did not drop the victim? It was the 15-year-old's punch that led the victim to fall, and that's why he's facing more serious charges?
We took a look at their investigation to determine what degree of involvement each of these individuals had. And because of that investigation, we have not charged the 16-year-old with the manslaughter or participation, conspiracy, aiding and abetting the manslaughter.
Even though, according to your description here, he threw the first punch. Is that right?
I can tell you that he did. The basis for that assault, as Ms. Wilt has stated, was a separate physical incident with the victim. It was not, obviously the assault charges pending on the 16-year-old were because of a separate incident, not because of the punch that was the deadly punch.
And just to be clear,
Mhm.
you have knowledge that, I guess you're not able to get into, of the criminal past as it relates to these two individuals, which sort of encourages the charges for adults?
Yeah, I can't confirm or deny any criminal past with regard to them. I can tell you that that is something that prosecutors take a look at in determining whether we file a petition for waiver. We take a look at all 5 of these criteria. We can't tell you which ones weigh more heavily than others or whether some did not weigh at all. We can just tell you we take a look at all 5 of these criteria as a whole and make a decision about whether to file a petition for waiver.
And can you talk at all lastly about just some of the community concern and input on what you pursue here in regard to this case, people on both sides of the altercation?
Certainly, I think you're all aware, there's been a lot of community involvement on both sides. And for us, quite frankly, we have to ignore it. Obviously, public safety is an issue in terms of the public as a whole, but not as a special interest group. We just ignore it. We do our job. We ask for the investigation to be completed. We guide them somewhat and say, maybe take a look at this, interview this person as well. Did this reveal that? We take a look at it. The law's the law. I don't make the law. I'm not a legislator. We're prosecutors. And we put the two together. We'll move forward from here. If you do this and you start catering to special interest groups, that's not the oath that we took. We're independent for a reason. We take the community. We have to ensure that the rights of the victim are considered, the rights of the defendants and petitioners, respondents are considered, and the rights of the community. So, and that's the same in every case. I know people want to make a big deal out in this case. It's the same in every single case. It really is. So I just can't make comment on that other than to say, again, we want to ensure that these young men have a fair trial. That's why I'm not commenting on any of that stuff. They have a right to a fair trial with as minimal amount of pretrial publicity as possible. However, I also have an obligation to let you all know and the community know what happened in court and where we go from here and whether new charges are filed, which we did, whether new motions are filed, which we did. To get into the content of those motions and what we're going to be arguing or what they're going to be arguing is not something I'm allowed to do.
The second-degree assault charge for the 16-year-old, is that because Lee was defenseless as he's spitting on? Can you get into that at all in terms of how?
I can just tell you that again, as Ms. Wilt stated, that it's for the spitting on the ground is the one charge of the assault. The other one is for a separate assault occurred apart from the 15-year-old assault.
Mr. Smith, just
Yes,
to
ma'am.
clarify,
Yeah.
hate crime charges are not being filed, but could it change in the future?
We believe that the investigation is complete, and they've done a very, very thorough job. The detectives, we're fortunate to have excellent police and detectives in this community. It's a complete investigation, and we filed the charges we filed. They do not include a hate crime.